Thank you. Morning, supervisors. My office, the Public Defender's Office, provides legal representation to 28,000 people every year, including in that number are 2,000 children who we represent through our juvenile unit. These children are entitled to competent and effective legal representation under both the United States Constitution and the California Constitution. This right is not based on their immigration status. And this means that the basic rights that they are to be afforded must be given to them. As you know, I've been short-staffed, but we've done the best we could to provide representation for all the children that need it. And as the attorney for the child, we have the responsibility of ensuring that the child's rights are respected, that the cases are properly investigated, that witnesses are interviewed, and that we determine the facts, what the facts are of underlying the arrest. And where there is a legal defense, we raise that defense in court. The current policy deprives us of the ability to fully investigate the case before a child is referred to immigration. And it's really a question of due process. What Supervisor Campos's legislation does is ensures that before a child is reported to the immigration authority, we first make sure that a crime has been committed. Now, in juvenile court, there is no right to a jury trial. That's one big difference. And the determination of guilt or innocence is made by a judge. So under this legislation, a minor would not be reported unless the case was first proven to a judge. And there's a very good reason that we treat children differently than adults. A child may be living with his or her parents, and to deport them to another country has severe consequences, not only for the child, but for the family. I should note that there are situations where the child is unaccompanied by an adult, and in that situation, they may choose to return to their families in their country of origin, and often this is the outcome. I also thought you might be interested to know that of the 2,000 children we represent each year, less than 2 to 3% are undocumented. For example, since June of 2009, this year, we've had 19 children who have been undocumented. Of these cases, there were 4 children who were arrested for felony crimes, but the charges were later dismissed. So about 20% resulted in no charges. This legislation will ensure that children who are later exonerated or where charges initially filed are later dismissed do not suffer the consequence of deportation. The legislation will give my office the opportunity to investigate a case, and where there's evidence of innocence, we will be allowed to present that to a judge. Under the current policy, because an arrest requires authorities to report a child to ICE, there is no opportunity to prove or disprove the charge. We had one case where a young man, 17 years old, was charged with a very serious crime, a robbery. After a thorough investigation of the case, it was determined that he was innocent. And actually, the district attorney dismissed the case and declared in court that he was innocent. And so in that case, he was still deported. He was still referred to ICE. And so this legislation simply moves the reporting requirement to the point in time after determination has been made that a crime was actually committed. It's good, sound policy, strikes a balance between protecting public safety and helping us achieve the best result for children and families, irrespective of their immigration status. Thank you.